I'm Russell de Souza. I'm a director at Fideres, and I'll be presenting today's webinar on data breach cases, and in particular looking at methods to quantify loss in these types of cases. Today's webinar will be approximately 20 minutes, and we will do a Q&A at the end of the presentation. So if you do have any questions, please feel free to use the Q&A box in your dashboard to ask them. So starting off with agenda, we're going to talk about the data breach landscape. We'll be looking at differences between the US and Europe, and we'll be focusing on the UK and looking at some of the fines that have been issued there. The bulk of the presentation will look at a range of different damages methodologies, which have been used in the past, and we'll be including some examples. And then we'll conclude with some of the issues facing the courts on deciding which methodologies to use. Now, one of the reasons why we're hosting this webinar is that we see cybersecurity, data privacy, data breach cases as a growing area for litigation over the next few years. And this Norton Rose survey from 2019 shows quite clearly that cybersecurity is on the top of the agenda for law firms over the next few years. And an example of this is our current economic climate that we face. So I'd be remiss if I didn't mention COVID-19 and the impact that it may have on data breach cases. And we see two areas in particular where this pandemic may give rise to data breaches. The first being the adjustment to working from home. So many companies globally have had to quickly adapt to the circumstances, and they had to make arrangements for employees to be able to work from home. Without adequate time to check the security measures in place, there may be personal computer vulnerabilities, which would give rise to data breaches. But another more indirect area that we've been thinking about is all of these apps that have been created to track your movement, track your health, track symptoms. And we've seen in South Korea, there's an app, Corona 100M, and this app alerts users when they come within 100 meters from a location visited by an infected person. And this app uses government data. We've seen in China, we have Alipay Health Code, and this assigns color ratings to individuals to indicate their health status and can be used to determine whether they should be quarantined or not. And in the UK and US, we have kind of COVID-19 symptom trackers where you can record your symptoms, you can record your location. And this can be used to help medical professionals better plan their responses. But there are a few questions that arise out of all of this. What security measures have been put in place to protect this kind of sensitive data in such a rush when these apps were released? And also, whether the data that is collected during these moments of crises could later on be used for other purposes without the user's knowledge or consent. And so this will be something that, as everything unfolds, we'll be keeping quite an eye on. So moving on to the legal frameworks. So it's interesting to contrast the US and Europe here. So in the US, there's a bit of overlapping patchwork of legislation. So different states have different legislation and different types of data governed by different rules. So an example here is California, which has the California Consumer Privacy Act, the CCPA, which was passed in 2018 and came into effect this year. We also have Vermont that has its own state legislation, but also different types of data are governed by different laws. So the HIPAA is focused on medical records, whereas the COPPA is focused on children's privacy. And it's interesting to contrast this to Europe, where GDPR came into effect in May of 2018. And this single comprehensive legislation governs multiple countries in Europe, as well as different types of data. And this is one of the reasons why we've seen a large increase in data breach notifications in Europe. And if we focus in on these European countries, we can see the UK is leading the way in terms of the number of complaints by national data authorities since GDPR came into inception, with over 30,000 complaints in the year after GDPR came into effect. And focusing a bit more on the UK and looking at fines that have been imposed, there are a few things that stick out. The first is that there are a few much smaller fines around the kind of 500,000 mark. And the reason for this is any data breach which took place before GDPR came into effect was capped at 500,000 for a fine. But the two that really stick out are the British Airways 183 million and the Marriott 99 million. Now these are just, these fines haven't been finalized yet, but the ICO have given indications that this is the order of magnitude that they're looking to pursue for. And so it's quite clear that the ICO is taking these cases seriously. And I think just yesterday, Marriott announced another data breach, a separate one from this fine, which apparently affects about 5 million guests. Marriott said there was no payment data that was stolen, but there was personal information, names, addresses, date of births, and travel information. So this is clear this is something that is ongoing. Now, moving on to damages methodologies. There are two broad approaches that have been used in the past. The more judicial approach used in the courts has tended to look at a more personal, subjective view of data. And we contrast this with a more academic approach, which focuses on the market value or economic value of data. And we'll be going through each of these types of approaches in this section. So starting with psychological distress. In this approach, even if there's no direct financial loss, we have seen a few UK cases where damages have been awarded for psychological distress of the victims. And these have tended to be slightly more focused on the data privacy side and usually to do with a small number of individuals. So an example of this is in 2016, where 6 asylum seekers received damages awards of between $2,500 and $12,500 after their personal data was published on the Home Office website. Now, one of the big issues here is to do with commonality. So how can we show that after a data breach occurred, each of these individuals had distress after that event? And there's also a big question mark about how do you put a monetary value to some level of distress that has occurred? Now, this is perhaps one of the simplest conceptual approaches to damages. So here we're looking at the monetary losses directly resulting from the data breach. So an obvious example here is fraudulent credit card purchases following a data breach of payment card information, but also identity fraud would fit into this category. And a key issue here is, again, to do with commonality. So this approach would require claimant or plaintiff specific fact-finding to get a sense of how much this fraudulent purchases were. And also in the US, there's a precedent which compels plaintiffs to show harm to be certainly impending as opposed to objectively reasonably likely. And this just means there's another hurdle to bring these types of claims in the US. Now, this is a slightly more indirect theory, and it supposes that consumers incur harm through the lost time spent mitigating the effects of a breach. We can think of this as the time spent freezing bank accounts, setting up alerts with credit reporting agencies, or monitoring credit reports. And a nice real-world example of this is in the US, where the retailer Target had a data breach, and as part of the settlement deal, victims would be reimbursed for lost time. Now, the time value in this case was $10 per hour, and the individuals could only be reimbursed for a maximum of 2 hours for dealing with each instance of substantial loss. And again, one of the big issues with this approach is to do with commonality. So different people will clearly spend differing amounts of time trying to mitigate their data breaches. And now if we move on to the more kind of market-focused valuation of data. Surveys and economic experiments are another means of extracting the price at which firms would need to pay individuals to disclose their personal data. From a 2013 study, depending on the type of data in question, the consumer is willing to accept differing amounts. And intuitively, that kind of makes a bit of sense. So an individual might value their user browsing history higher than giving away their phone number, for example. And one of the issues here is the lack of market verification. So the surveys are based on this kind of hypothetical estimate of the value of data, and this may differ from real-world situations. Now, this is quite an interesting approach. It looks at the financial position of data-intensive companies in order to infer a valuation at a more granular level. So to put this into context, you can think about the likes of Google or Facebook. So they are these big digital advertising companies whose primary purpose is the collection and analysis of users' browsing and social data. And for these large publicly listed companies, we get very accurate data on revenues and the number of users over time. And this allows us to calculate the average revenues per user, the ARPU. So if we take Facebook as our example, in 2019, Facebook made revenues of $70 billion US, and they have about 2.5 billion users. So we can use these figures to calculate the ARPU for Facebook to be $28. And we can think of this as a rough proxy of the value that Facebook generates from 1 year's worth of data for a single individual. And we can also compare this to other social media platforms. So Twitter, for example, has an ARPU of 5.68, Snapchat 1.91, and Pinterest 91 cents. And one of the issues we have here is that these estimates may actually be inflated, as they also include the sophisticated proprietary algorithms that the likes of Facebook are able to deploy. Now, moving on to regression of market prices. The idea here is that once a data breach has occurred and the data is effectively stolen, there are illegal markets where the buying and selling of this data takes place. And one can observe these different prices set in the black market for different types of data. And this means that when a data breach does occur with multiple types of data being exposed, this approach can use regression analysis to isolate the value of different components of data in order to arrive at damages estimates. And it's important to note here the shelf life, which is the time frame when the information is valuable, can play a big role in valuation. So medical information can be highly valuable as this information doesn't change over the subject's lifetime. However, we can contrast this with credit card information, which becomes virtually worthless after a few months, as the subjects will have blocked their details by then. And the big issue that we have here is prices on illegal markets are notoriously difficult to collect. So these estimates can be highly subjective to biases due to unrepresentative samples that are taken. And now, kind of moving on to some closing remarks, I've spoke about these two broad categories of approaches when looking at damages. And you get the sense that there's a bit of a tension between these two approaches. So on the one hand, you have this more subjective view, which is focused on the kind of the personal valuation of data. And on the other hand, you have a view which is focused purely on market valuations of data. And the big question here is, how do we reconcile these two approaches to get to a method where we can quantify losses in data breach cases, but they're both accepted by the courts, but still grounded in robust economic theory? And at Fideres, we appreciate there's no single or simple answer to this question. But one thing we have been doing is we've been looking at recent cases just to get a sense of what the future holds in terms of damages for these types of cases. And one of the cases in particular we've been looking at is the Lloyd versus Google case. And so for anyone not familiar with this, this is a UK claim against Google on behalf of Apple iPhone users. The allegations are that Google placed cookies in these devices which bypassed Apple's Safari default settings, which automatically block third-party cookies. And this allowed Google to deliver ads to users based on their browsing history without the user's knowledge or consent. The High Court initially threw this case out, but in October 2019, the Court of Appeals overturned that initial decision. And the reason why I talk about this case is that the judge made quite an interesting ruling. The judge said that someone who has lost control of their data can be compensated regardless of whether the breach caused any distress. This means that anyone using this data without the subject's permission has effectively deprived them of control over that asset. And this loss of control suggests that data breach victims are entitled to a form of damages known as user or negotiating damages. And this theory of harm stems from the idea that an owner of an asset ought to be able to decide the terms on which he or she is willing to lend it out to others for its use. And if we're looking at it from that view of this negotiation between an owner of the data and a third-party data collector, this is very interesting from an economist's point of view, as there are well-established economic models for analyzing these types of cases. And at Fideres, one framework in particular that we've been looking at is Nash bargaining models. And the key insight from this framework is imposing all negotiations as a discussion between how to split up the rewards of some sort of collective venture. And to help put this into context, you can think about a third-party data collecting company. If they're able to get their hands on some users' browsing history data, they could then take this to advertisers and sell it for a fee of X dollars. Now, as we said earlier, it doesn't really make sense for this data collecting company to get 100% of the fee, as we mentioned this kind of user damages theory where the user has control over their data. They should be able to decide the terms, and so they should get some slice of this kind of final fee. But we're not saying that the data subject should get 100% of the fee, as the data subject isn't able to extract this tangible economic value from their record of data. But what the model does do is it gives us a sense of the upper and lower bounds of this hypothetical negotiation. And it does this by looking at each side of the negotiation. And it determines the value at which each of the parties would actually prefer to just stick with the status quo and simply not transact. And so from a data subject's point of view, it would be exercising their right to privacy and maintaining control of their data. And from a data collector's point of view, it would be just simply not being able to process that user's data, which may lead to lower computing costs, for example. And this model can be extended even further to incorporate differences in negotiating power between the two parties in order to determine where in this range the optimal outcome would be. And this relatively kind of simple framework may provide a solution to reconcile the more market-focused academic approach in such a way that can be more easily used by the courts. And so with that is the end of the presentation. Thank you everyone for joining.